When I got the invitation to present at this workshop, I got really excited, and that's not just because I tend to get nerdy about these things, but I actually saw this workshop and the theme of this workshop as a great opportunity to sit back and reflect on what I've been doing for the past decade or so in a variety of areas, because I think the theme is quite relevant to much of the work that I do. So I'd like to thank Julia and Evan for the opportunity to be present here today and to present to you on legal kinds. The other reason I got really excited is that I rarely go to conferences where I'm the only lawyer in the room. So no one can actually contradict what anything I say today, which is great. I suppose I might get some pushback from philosophers, but I'll just say that doesn't apply.
You can't contradict anything.
Yes, but I will just raise an objection to it, and then that'll be the end of it. So I want to talk to you today about legal kinds and how lawyers deal with classification, specifically in the context of biomedical research, which is the area that I work in. And that's because classification is actually very important to what lawyers do. But more fundamentally, it happens in law in a way that's, I think, and I'm going to argue, is quite different from the way it happens in science and perhaps in philosophy and other fields. Lawyers tend to use classification in a variety of ways. They use it to define, to interpret, and to persuade. It is actually a big part of what lawyers do. They like to classify things. They like to include and exclude. For lawyers, classification is not just about form. It's also about substance. It's about meaning. They can use it as a way to include things or exclude things from what they're trying to establish. So here's an example of a rule of interpretation that we use in law. I use them generis. This is a rule of interpretation that judges apply when they're dealing with a statute or a case where there's things that need to be interpreted, and they're trying to decide if they want to include or exclude something in a classification of things that they know about. So the rule says that where you have a class of things that is followed by general wording that is not itself expansive, that wording is itself limited to things of the same type as the listed class. So here's an example. If you have apple, orange, pear, and other, then other can only be something that is of the same kind as an apple, orange, or pear. In law, anything else that you put forward, you can't convince a judge, once this rule is being applied, that that thing belongs to this class, simply because this rule has already been established, and the rule ossifies the classification. It cannot change. The judge will not accept anything else because someone has convinced the judge that this rule should apply. And that leads me to the thesis of my talk. I'd like to start with my conclusion, which is that classification is one of the ways through which law and science collaborate, clash, or compete for the authority to define and regulate social order and progress. Now, I've highlighted the three C's over here: collaborate, this is the pointer work, collaborate, clash, or compete. That's important, and that's actually based on academic literature. It comes, in fact, from work done by Sheila Jasanoff, who is a pioneer in the field of science and technology studies. She's at Harvard Kennedy School, and she authored a piece in the Handbook of Science and Technology Studies called Making Order, Law and Science in Action, where she argues that law and science are two social or cultural institutions, and they sometimes work at cross purposes with each other in their attempt to define social order and progress, and sometimes they collaborate. And how they do that depends on the specific situation in play, and that what you find most often than not is that these two cultures tend to clash, and when they clash, they produce outcomes that may be unfavorable to science. And I think classification is one of the ways through which law does this. And the primary reason for this is because I think in science, scientific classifications tend to be, as we've seen from yesterday and the talk this morning, they tend to be fluid. They're not watertight compartments conceptually. But in law, classifications tend to be ossified. They tend to be less flexible, and that's just because of the way law works. When politicians get together in modern liberal democracies and they create law, they define things in the laws that they create. Those things rarely change over a long period of time. There are laws still in force today that were made in the 19th century, and those definitions tend to influence things in the present. And when lawyers and judges are called upon to interpret them, the default rule of interpretation in law is the literal rule. Read it as it is in the text. It doesn't matter when the text was made. It doesn't matter what the context is that informs the text. As a matter of fact, there's a school in legal philosophy that argue that you should never try to discern the intent or the meaning behind the statute. You don't want to know what the legislator was thinking about. You don't want to know what the context is. You just want to look at the literal meaning of the words on the page and go with that. And if that is unworkable, there's not much room for flexibility. There are other rules of interpretation, but lawyers and judges tend not to stray too far from the thing that has already been set. And that, I think, is the main challenge that leads to this story of collaboration, clash, or competition. So I'm going to give you 3 main examples of how this happens in the interactions between law and science. I'm going to discuss 3 case studies which are drawn from the work I've done in biomedical research and the ethics of biomedical research over the years. So the first way is looking at legal and scientific kinds in stem cell research. And I'm very pleased that Melinda spoke before me, because I think she's made my job here very easy. And I think our talk does show that the way we think about stem cell classification in science is a very fluid concept. It is not set in stone. And I think that's where you're going to see a lot of problems emerge as you start to think about the influence that law has on that classification. So in scientific terms, new kinds are not conceptually watertight categories. I think that is pretty much established now from the talks we had yesterday and from the talk we had this morning. We had Melinda's change through experimental methods, which she talked about a few minutes ago. Alok's making history concept. I mean, this is great for me personally. I feel like my paper was writing itself as I sat there listening yesterday. I've been thinking of ways to try and make this point, but I think the point has been made for me already. The 2 Evans alluded to this in their talks. John talked about classifying nanomaterials and the challenges with that. I think it's pretty clear now that these are not conceptually watertight categories. A clash of culture arises, however, when law treats them as such. Law treats them as something that's ossified, that is fixed in time, in temporal terms and in special terms. For law, the concept of change doesn't come very easy. Now, in Canadian constitutional law, we have something called the living tree doctrine. This notion that law is like a living tree, and as the tree grows, you change with the tree. But it's something that's applied much in the context of public law, and specifically in the context of interpreting our Constitution. It doesn't quite flow into other areas of law, and it's not made a very pronounced presence in the context of biomedical research and the way that law affects biomedical research. For the most part, law tends to be inflexible to change. It tends to be stuck in time and in meaning, and that can create a clash of cultures between law and science. And I think the clash has important consequences for biomedical research, and I'm going to discuss 2 specific examples as it relates to stem cells and how this clash happens in the context of stem cell research. So the first is with respect to induced pluripotent stem cells as a new kind. We've already talked about iPS cells and what they are. Melinda did a good job of telling us what they are. And scientists do tend to treat them as a new kind that is different from the controversial kind, which is human embryonic stem cells. Now, scientists will tell you that human embryonic stem cells are the gold standard. That's what they want to use for their research. But induced pluripotent stem cells have come along based on a constellation of factors that have led to their discovery, and are now being used as a new kind in the context of stem cell research. Now, the derivation of embryonic stem cells, as we know, is ethically problematic, and in some cases, it is in fact outlawed. In the US here, it is difficult to make anything that's scientific illegal because you have a constitution that says that if you can think it, then you can do it. In some states in the US, human embryonic stem cell research is in fact banned but at the federal level, it is not. In Canada, we have a ban on creating embryos specifically for research. So in Canada, you can't actually create embryos for research. I know, I can see, everyone looking like, what are you talking about? Yeah, we do have strange laws in Canada from the perspective of an American. And there are other countries as well that ban human embryonic stem cells for the reason that the derivation of stem cells from human embryos leads to their destruction. And that has created, big controversy, same thing as you have with the abortion controversy. And that has led to a ban in many jurisdictions on human embryonic stem cell research. However, there's this distinction that's made between human embryonic stem cells and adult stem cells. As we heard in Melinda's talk, when people are doing adult stem cells, that's supposed to be the good kind of stem cell research. Everyone loves that one. Everyone talks about it like it's the thing we should be doing. Someone who likes it in particular is your ex-president, George Bush, who announced in a speech that he gave that, embryos are like snowflakes. No one wants to destroy snowflakes. They all have unique potential. We can't treat them this way. That what we need to focus on is on adult stem cells. So that classification, adult stem cells, is supposed to be the good stem cell, the one that you can do research on without any controversy. And human embryonic stem cells are supposed to be the ones that raises all these kinds of challenges, ethically, morally, and legally.
Trust me, George Bush did not write that statement.
Well, he read it. So adult stem cells, generally speaking, are not subject to the same bans you have on embryo research. As I mentioned before, several states in the US ban human embryonic stem cell research. And if you're thinking, what do these states have in common with Poland, Colombia, and Tunisia? It is this ban on human embryonic stem cell research. But adult stem cells, no one regulates that. And this is really interesting from my perspective. It is rare to find examples of direct regulation of research where you actually see lawmakers come together and say, we're going to use the law, we're going to throw society's will, through law, and impose that on an area of research. In Canada, it's rare to find an example of any statute that bans any area of research. This is the first example we have with respect to human embryonic stem cells in Canada. In the US, it's even more rare to find this example of direct regulation of research. So this is quite significant. However, adult stem cells are spared the indignity of having legislation imposed on them. But then you get induced pluripotent stem cells, which are classified as adult stem cells. And we've already learned about what they can do. They have the same potential or similar potential to what human embryonic stem cells can do. But they are classified as adult stem cells. But this is half of the story. And this is where you start to see these different forms of classification in law and science start to have an actual effect on how science is done. Now, the differentiation of induced pluripotent stem cells into germ cells is actually what scientists want to do. I once gave a talk to a group of scientists at University of Toronto, and they got up and they spoke before me, and they got all excited about what they're going to do with iPS cells. So the idea is that we can keep trying to return them to that very early stage where we can derive sperm and egg from the iPS cells, right? And I let them have their moment. They were all very excited about this. We're going to derive sperm, we're going to derive eggs. And then I stood up and said, that will be banned by law in Canada. Like, how can that be banned by law? Nobody even knew about this when the law was enacted in 2004. I'm like, yeah, but law is not drafted in the kind of language that anticipates the future, right? And what might happen in the future. Canadian law inadvertently bans the derivation of sperm and egg cells from iPS cells. Now, of course, you can derive sperm and egg cells, but anything you attempt to do with it is also banned by law in Canada. You can't actually fertilize them. If you do, that will be considered cloning. So when I told them this, they were not very happy. I've not been invited back since then. I'm sure they're doing it, but no one wants me to be in the room and tell them that what they're doing is actually illegal. So this new kind is possibly and inadvertently banned in Canada because when we made our law in 2004, no one, this was not the horizon, no one had any idea that this was going to happen. But the law was drafted in language which suggests to me, and quite strongly so, that if you try to derive germ cells from iPS cells, that will be banned in Canada. Now, it's not just a ban for the sake of it being a ban. It's actually a criminal offense. If you did that, you could go to jail for 10 years. Sorry, you could go to jail, 10 years, or you're subject to a fine of $500,000, or both. So it's pretty significant. I mean, you're better off just robbing someone than actually trying to create germ cells. Now, there's another reason why it's banned. So even if you don't fertilize it, the main reason why it's banned is that under Canadian law, if you derive germ cells from genetically altered iPSC, so you remember that with iPS cells, what you do is you introduce some genetic factors. Under Canadian law, any attempt to derive stem cells from something that has been, any attempt to create genetically altered germ cells is banned by law. And the reason why that was banned initially is that there was a fear that persons who want to create designer babies, so if you want to have so-called designer baby, you want to create a baby that has certain characteristics.
So when they say genetically altered, I mean, they don't mean DNA sequence alteration, because that's not changing.
No,
Or it doesn't have to.
it doesn't have to. Introduction of it will be considered banned, just
So
introducing it.
Just bringing like that transient burst of expression counts as genetic alteration.
So if it's a non-natural germ cell, non-natural in the sense that you've introduced some kind of technological improvement of it, and you've used genes to do that.
Well, the germ cell isn't going to have that changed burst. It's a transient. Like, it happens earlier. You don't have any weird expression with the germ cell.
Well, this was
the route that you take to make them is still
right. It's still a part of it, and this was such a problem that scientists in Canada actually figured out a way. They call it the piggyback method, a way to extract the thing that causes the change to iPS cells before they use it, right? So the scientists actually now in Canada trying to work around the problem created by the law. But the idea here is that when this was originally drafted in law, the intention was to stop people from altering germ cells to create babies that have desired genetic characteristics. There was no idea that this will somehow down the road affect the ability to actually derive stem cells, germ cells from iPS cells for research purposes. Now, such germ cells, if fertilized, will, under Canadian law, constitute a clone. The way clone is defined under Canadian law, that will be a clone. And that is a no-no under Canadian law. If you did that, that would be a big problem under Canadian law. So this is an example of how these narratives in law and science compete and quite possibly clash. Now, scientists are trying to make order by getting around some of these ethical problems around human embryonic stem cells. They're trying to move science and social progress, if you will, forward in some kind of way. And then law is also creating another narrative, which then creates competition between these two cultures. Now, the second example I'll give is with respect to cloned and interspecies embryos as new kinds. Again, scientifically speaking, an embryo is an embryo is an embryo. Most scientists that I've spoken to will tell you that when they do their work, they don't tend to think of these materials as constituting various kinds the way that we approach it in law. So this is the reverse of what I just described. An embryo should be an embryo, should be an embryo. Now to illustrate how perhaps this question can be significant in the context of the discussions in law and science, I have a clip from Seinfeld because Seinfeld always explains things to me in a way that I can understand. But in trying to answer this question, when is an embryo an embryo? I don't know if you recall this clip about Kramer trying to make a pizza.
And cucumbers. It's cucumbers.
No, you can't put cucumbers on the pizza.
Well, why not? I like cucumbers.
That's not a pizza. Y lo face it.
Yeah, but that's the idea. You make your own pie.
Yes, but we cannot give the people the right to choose any topping they want. Now, on this issue, there can be no debate.
What gives you the right to tell me how I would make my pie?
Because it's a pizza.
It's not a pizza till it comes out of the oven.
It's a pizza the moment you put your fist in the dough.
No.
All right. So when is a pizza, right? I mean, in scientific terms, scientists that I've spoken to, when they produce these materials, they see them as basically an assay to use in doing their work. But in law, we tend to make distinctions between one kind of pizza as another kind of pizza, and that's because the law has been created by politicians who want to see a difference in all of these things. And those differences do tend to create a clash of cultures as well, as I'll explain shortly. So the first example is an interspecies embryo, something that has been described as a cybrid or cytoplasmic hybrid. And this is created where you take, ova from an animal, you take out the nucleus from the ova, and then you take the nucleus from a human cell and inject into that egg, and then create a very early stage embryo that has the same characteristics as a human embryo, but part of the genetic contribution comes from, at least cytoplasmic contribution comes from an animal. Now this creation, if you fertilize human and animal germ cells, the question then arises, is this the same as the human embryo? Does it raise the same kind of issues? And is there any reason why we should apply the ban that we have on human embryos to the ban on this kind of embryo? Now, scientists in the UK created this type of embryo because they wanted to do research on it, because they wanted to avoid the issue with trying to get ova from women. This was a big issue in the UK, the procurement of eggs from women. There was all kinds of debates around that, about whether we should be paying women for their eggs, about the fact that there's a scarce supply of it. It is procured in a situation that's very invasive, and so there was an attempt to get around it. Now, when they applied to do this experiment, there was a huge public outcry against this. And the issue is that, as some defined it, is that if you look at UK law, this is an embryo, same as a human embryo, and you can't do to this anything that you do to a human embryo. Now, the other argument is that this is not, in fact, something that's covered by law in the UK. That embryo in the UK means human embryo, and this is not included in the definition of human embryo. And as a result, the law does not recognize this entity, and if the law does not recognize this entity, then you cannot create or do research to this entity. So it's a convoluted argument that I'll get to shortly. Now, you also know about clones. You can also create a clone using sort of this process where you create a new kind of embryo, which is basically produced from one person, right? One human person, and you create a cloned embryo from that as well. And again, the question arises, is an embryo created by cell nuclear replacement the same as a human embryo? Now, an ordinary embryo is an entity that has a diploid set of chromosomes obtained from male and female germ cells. That's your classic embryo. And then we have a clone, which has a diploid set of chromosomes, which is obtained from a single human being, fetus, or embryo. This is actually how the Canadian law defines a clone. Whether or not that is consistent with the science is not important for our purposes here, but that's how it's defined under the law. So the issue is then, are new kinds that have a diploid set of chromosomes that are created by methods other than fertilization embryos? So if anything is created by scientists that doesn't fit that classic definition of fertilization of male and female germ cells, can we call that an embryo? And this can have huge consequences for what scientists are allowed to do in different jurisdictions. So the first example is this case, Regina and Secretary of State for Health, ex parte Quinterville. Quinterville is the name of the president of a pro-life group in the UK that brought a challenge against the UK regulator, when scientists attempted to make an embryo that I described before as the cybrid. They wanted to make a cybrid. So Quinterville took them to court and argued that UK law defines an embryo thus as a live human embryo where fertilization is complete. So Quinterville argued that because the term fertilization is used in the definition, that any embryo that is created other than by fertilization is not covered by the law. And as a result, the UK regulator had no authority to issue a license with respect to an unregulated entity. And this was an attempt to stop scientists from creating a cybrid. If it's not regulated, that means you don't have the authority as a regulator to actually issue a license to create it. That was the issue in this case. And so this was an attempt to use law in a statute to actually stop scientists from expanding the categories or from creating new classifications, even though those classifications in scientific terms don't matter much. The distinction, I mean, doesn't matter much in scientific terms. All they want is to create an early stage embryo so they can study developmental activity at that level. The court disagreed with Quinterville and ruled that the UK Act applies to a human embryo, however created. But this was a very sort of forward-looking panel of judges. You can even call them pro-science, if you will. I think that's what it results in if you read the case. Because what they did was to say, we're not going to apply the literal rule of interpretation that I spoke about before. We're not going to look at the statute or that definition, the way it is here. We're going to try and decipher the intent of the legislator. And that there's no way UK legislators will create a statute that has this much social significance and then have it fixed in time. They must have anticipated changes. This is the definition they used is what they knew about at the time. They did not anticipate that there'd be attempts to create embryos other than by fertilization. But now that that has happened, if they had known about it, they would have included it. Because if we look at the statute as a whole, if we look at its purpose is to create a framework to regulate all embryos. Now, this is an interpretation that will probably fail in a place like Canada. I don't see our judges being this activist and going with this interpretation. But this, I think, is an example of how law and science can actually collaborate, of how judges can actually expand the categories.
I'm sorry, so I'm missing something. So by doing this, saying this, and then what the scientist was attempting to do is not a human embryo, so he could go ahead?
Right. So the regulator could issue a license
Okay.
for them to create that embryo.
Okay, so by defining it this way, they're saying that putting human tissue or in a cow doesn't create a human embryo.
It doesn't. It creates an embryo. They're not concerned with the human. So they're saying the notion of human,
Yeah.
right, is not important.
Okay.
If you're trying to define an embryo for legal purposes,
Yeah.
what's important is that it looks like an embryo.
Okay.
So if you think about the Ejusdem generis rule,
Yeah.
it looks like the same thing that you've always considered an embryo.
Yeah.
So it's an attempt to say we don't care about the use of the term human.
Yeah.
And again, it goes to the question I asked Melinda. Scientists invented that classification, but the judges are saying we don't care much about that.
Yeah.
We care that you have something that looks like the thing that was there before.
Yeah.
And if you create anything at all that looks like that thing, that is allowed by UK law.
Okay.
So they moved away from the actual wording of the statute to say anything you create that looks like an embryo is an embryo.
Okay.
It doesn't matter what you use to do it. It doesn't matter where your source comes from.
Yeah.
It doesn't matter what you're combining, so long as it looks like the thing that was there before. Now in Canada, if you're tempted to go with the UK decision, like I said before, that's a criminal offense. You couldn't possibly do that. There's a maximum 10-year imprisonment for that, and because the law says no one shall knowingly create a clone. If you try to argue that a clone is an embryo or that a cybrid is an embryo, under Canadian law, that would be banned. And so Canadian law is an example of the ideas of culture clash and competition.
Wait, what happens if you accidentally? I don't know.
Like in your garage or something?
Yeah, like I'm trying to do something else and you accidentally.
Well, interestingly, that's what actually led to the reaction we got in Canada from legislators. There was a claim sometime around 2002 by a group known as the Raelians in Canada. It's a cult, really. There's a religious cult that claimed that cloned a human being, that produced a full human clone. It turned out to not be true, but as you can imagine, the media went crazy. There was a lot of publicity around the issue. Before that story, Canadian legislators had tried to enact some law around this, and there have been several failed attempts to do so. But immediately after that story broke, they came together and they enacted the law that we have. And if you read the parliamentary debates, there's talks about people in garages, in their homes, doing this kind of stuff, which we know is impossible. No one is going to set up a lab in their garage to create a clone. Even if you did, you're not going to succeed because it's so technically difficult to do so. But they reacted to that, and then they created definitions and categories based on their feelings on the subject at the time, and that has now affected things going forward. All right, here's another example. This is a US example. Since I'm in the US, I feel I'm obligated to talk about US cases. But this was a case filed by two researchers. I forget from what university. Now, there are two researchers who work on adult stem cells. And they were pissed off for the fact that NIH was using federal funding to support research on embryonic stem cells. So they then argued, they brought a motion to prevent NIH from funding that research. They argued that because embryonic stem cells are derived from human embryos, that that kind of research should not receive federal money because there was an amendment to an appropriations rider in the US, which was introduced by Judge Bush, which says that federal money shall not go to any research that destroys human embryos. So the argument is that since human embryonic stem cells are derived from human embryos, any research on human embryonic stem cells, not human embryos, but human embryonic stem cells, is the same as destroying human embryos, and as a result, no money should go to research on human embryonic stem cells. As you can imagine, if the courts were to decide that no federal money should go to research on derived stem cells, that stem cells have already been derived from human embryos, this will shut down, essentially, an entire field of research. Without money, no one will be able to do the research without federal money. So that was their argument, that federal funding for research on stem cells that have been derived already is the same as funding research that destroys human embryos. The U.S. Court of Appeals in Washington, D.C. heard the case, and the issue was whether a research project in which human embryonic stem cells are used is the same as one in which they are derived, right? If you're deriving stem cells, you're destroying the embryo, but if you're using already derived stem cells, you're not doing that. And they argued these two things are the same. But the court disagreed. The court said no. So again, an example of collaboration. The court said no. These are two distinct categories, if you will. If you're using federal money to work on stem cells that have been derived already, that's okay. What the appropriations rider actually bans is research that seeks to destroy human embryos. All right, so the story, to sum up that first part, is that law can sometimes impede, but it can also sometimes aid the progress of science. It's not just one story. It's a story of how the law can sometimes open up avenues that people are trying to close down, while at other times limiting what scientists can do. But I do think, from my perspective and from just studying how law functions in the context of stem cell research generally, that the law does tend to take a more competitive approach to classification than it does in terms of collaboration. The second example is with respect to excised human tissue. Again, a very big topic in law, which has huge implications for the way science actually works. All right, okay, here we go. All right, so I'm sure most of you have heard about biobanks, which are basically biorepositories, places where you store biological materials. Now, if you look at a biobank, this is a schematic that talks about the things that are collected in a biobank. And this comes from published research from some colleagues of mine at the University of Minnesota. I was actually involved in this when I was at the University of Minnesota. but I left before the project was finished. But it was an attempt to describe the different kinds of materials that you will find in a biobank. So you start with collected samples, which could be blood cells or tissues, and then materials that are derived from them, which are also stored in the biobank, and all kinds of analysis and results that are done on those materials, which also are kept in the biobank. Now, for all these materials, the scientific fate of these materials is generally the same, but their legal fate depends on classification. And what I mean by that is this. As far as scientists are concerned, these are materials to work on. That's all they are, right? They think of them as basically one big category, things you have in a biobank that you can do research on. You go to a biobank, you fill out your forms, you get the material, and you do whatever research you want to do. However, their legal fate depends on classification. There's different ways these materials are classified, and that can have consequences for what use is allowed, for what you collect, for what you can share. It's actually a huge issue in law. And the classification that law uses has far-reaching consequences for how you collect, use, control, and share these materials. This is a frequently litigated area of biomedical research. It's an area that people tend to go to court for, and there's a lot of cases that describe the legal fate of these materials that is most of the time inconsistent with the way scientists view these materials. The dominant classification that is used in law is by the original reason for removal or excision of the tissue. Now, there's a misconception that scientists tend to have that use determines classification. So you classify it by why you want to use it, or that classification of the material defines its use. That's a misconception. The classification in law depends strictly on the original reason why that tissue was removed from the subject to whom that tissue belongs. Now, when tissue is part of your body, when you're a living person, you own your tissues, I hope. No one will suggest that your body doesn't belong to you. But the minute tissue is excised from your body, its legal fate then depends on the reason why it was removed from your body. There are two main kinds of tissue in law: diagnostic tissue and research tissue. This classification is very important, and it determines what happens to the tissue in legal terms the minute it's removed from your body. Diagnostic tissue is considered a hospital record. It is health information, and it has mandatory retention requirements. Almost every state in the United States and almost every jurisdiction has laws with respect to what you do with tissue that is removed from someone in the process of diagnosis and treatment in a hospital. So if you go into a hospital and tissue is removed from your body for diagnostic purposes, there are laws that apply to that tissue. It can only be used or retained in accordance with the law. Now, this includes excess or archived diagnostic tissue. Some of that tissue is taken and stored in a pathology department for years. And the ones that are not stored constitute excess diagnostic tissue, and those are discarded. Typically, excess diagnostic tissue is discarded after 7 days. Typically, archived diagnostic tissue is retained for as long as 27 years. So it's a long retention period for archived diagnostic tissue. And then the law defines what you can use that tissue for down the road. It is typically housed in and handled by pathology departments. Pathology departments are considered to be stewards or custodians of the tissue. They don't own it. They look after it. And they then release it for different legal purposes. So they can release it for future diagnosis. They can release it for testing, for other legal purposes. We've seen court cases where people actually wanted it retested because they felt they feel their doctor made a mistake with the original diagnosis and they want to sue the doctor for medical malpractice. There's all kinds of ways that that tissue could be used going forward. So the role of the pathology department is as a steward, and they make the decisions about access for regulated purposes. One of those purposes is research. The important point to note is that diagnostic tissue is not designated for research directly. There's a secondary process that allows it to be available for research. It is not automatically designated for research.
So, this is a weird personal aside. I had back surgery a couple years ago,
Right.
and they pulled out part of one of my intervertebral discs, and
Right.
because I'm morbid, I wanted to keep it. And they told me that I legally wasn't allowed to. Why?
That is true. That is because there's a law in whatever state you were in that says they can't give it to you.
But I mean, is there a legal justification for it? Is there a scientific justification?
Yes,
for
it's
it?
it's a biohazard to give it to you. So the primary reason is that we can allow you to take something that you don't have any means of treating it and disposing of it home. Anytime I give a talk related to this, people express all kinds of outrage about, what do you mean I can take my tissue home? And then I hear stories about people who brought their appendix home. I'm like, what? Why? Why would you bring something that's a diseased from your body home? But there are laws that say you can't do that. And that's mainly because it's a biohazard. So it has to be discarded. It has to be handled by someone who has the training to handle it. And then we have research tissue, which is tissue that is specifically collected for research purposes. It is not diagnostic. Someone walks in as a donor. They say, I'm a research donor. You take tissue from them. That is research tissue. That's the purpose for the collection. And you then provide consent to have it used or shared or kept in a biobank. Now, research tissue can be obtained through the diagnostic process, right? You can go to a pathology department and say, I need the tissue for secondary research. When that happens, the pathology department will then have to get it approved for research. And there's two ways that that can happen, or there's two things that have to happen when that happens. The first is that they have to get new and specific consent from the person, the patient, for you to use that tissue for secondary research purposes. And the second is that they have to get research ethics approval. You have to get that before you can use that diagnostic tissue, the archived diagnostic tissue or the excess diagnostic tissue for research. Now, until recently, courts have not recognized a right of ownership over excised tissue. The minute it leaves your body, you don't own it. It doesn't matter what happens to it. The scientific fate, as I said, is the same, but the legal fate, the minute it leaves your body, is that you don't own it anymore. There's a number of things that can happen to it, but the one thing that can never happen to it is for you to say, I own that tissue, even if it's commercially exploited. Say they derive the best cells from it, it becomes like, like HeLa cells, gold cells, the gold standard for science. You don't get anything. You don't own it, right? Now, once it's excised, it is no longer owned by the person from whom it's taken. Unless, of course, if you're smart and you get a lawyer involved. Unless you get a lawyer involved to negotiate something in a contract about that tissue, and there's no statute that actually says that that contract is void or that the contract has no effect when placed against the statute. Unless there's a specific legal encumbrance against that right, you can, by contract, create a right of ownership around your tissue. So you can, for example, go in for your procedure, and then you take your lawyer with you, and then you negotiate terms about that. But the problem is that there's a statute, I imagine, in California that says even if you have a contract, it's still a biohazard. And so it wouldn't matter anyway. But if that statute didn't exist, you can, in fact, have a contract where you say, this is what I want to do with my tissue subsequently.
But if a company provided services, then we'll provide you with a lawyer and provide you with credentialed biohazard management. We'll do the storage for you, like the company that does umbilical cord storage.
Right.
So if that service was provided,
Right.
you should be able to do it.
Well, that's because there's no statute that says umbilical cords have to be stored in a pathology department, right? Now, they can be discarded unless you provide a different means of storage. They're not going to give it to you, but they can give it to you.
Julia rents biohazard safe storage space
Right.
and storage services.
Right, yeah, that's okay. Yeah, you can do that. So that would be the contract that takes it outside of that's consistent with the law.
Because in today's genomic age,
Right.
that service, you're giving away your genome potentially for.
Right, except, of course, there are companies that now market that kind of service. We will store your umbilical cord. And the advice that's coming from bioethicists is don't do it. You're going to pay a lot of money to store something that might not actually help you in any way. But you have that option. You can do that because that's consistent with the law that says it's a biohazard and you have to find the right means of caring for it once it leaves your body. So I think this is actually an example of how law collaborates with science. This rule aids scientists because it protects what they do and how they source their materials from any kind of thing that the person who the material was taken from can do to try and interfere with the conduct of science in relation to those tissues. Now, here are some examples of that. These two cases sort of deal with this story of what can happen when tissue leaves your body. So in HESC, a deceased male person, so he had some sperm cryopreserved, and he had a contract with the cryopreservation company saying that in the event that he dies, the sperm should be transferred to his girlfriend, right? That was the arrangement that they had. Now, after he died, the company, of course, refused to. And then they said, once excised from your body, you don't have ownership over it anymore. They try to bring up cases that support this view that you don't own the thing once it leaves your body. But in that case, the court said, well, we don't see any statute or any specific legal encumbrance against the contract. And the contract does say that you can bequeath, that the sperm should be bequeathed from the girlfriend. And so the court allowed the sperm to be transferred to the girlfriend. Now, the deceased person's family protested the rule of, against the girlfriend's right to obtain the tissues because they didn't want the girlfriend to have the sperm and to create babies from their deceased brother's sperm. York is another case that also shows how contractual rights can be preserved in certain circumstances. Here, the plaintiffs went into a fertility clinic and created some pre-zygotes, which they then wanted transferred to another institution. And the court and the company where they cryopreserved it said, no, we're not going to let you transfer it. You must undertake the procedure here. And if you don't, then we're not going to let you transfer it because it's a biohazard and there are laws that say we can't transfer this and it no longer belongs to you anyway. And the court said no. So long as they're using it for reproduction, if they wanted to do anything else with it, they can use it to reproduce here. They can also move it to a different place. Like you said, they can transfer it to a different facility, take the same precautions, and be able to retain ownership. So that's the good news story.
So did that fall under diagnostic or research rules?
So that would be diagnostic.
Okay.
Yeah, both would be examples of diagnostic. These two cases are examples of diagnostic tissue. And patients saying, this is what we want to do with the tissue, except that it's coming up against this rule that says once it leaves your body, it no longer belongs to you, and you can't have it back. And the courts are saying in these specific instances, there are contracts that actually say, yes, you can have it back, and there's no statute that actually prevents you from doing so. So that's just...
a strange diagnostic case, right? I mean, it seems like kind of a gray area.
Well, in the second example in York, the court is saying only for diagnostic purposes. If you had asked for it to do anything else, then it's not. So if you were saying, I'm going to take this and take it to a company that's going to derive some kind of cells from it and then exploit those cells, then no. Right? But for diagnostic purposes, for reproductive purposes, you can have them and you can transfer them to the new facility. All right. Now, recently in Canada, we had a case from a very low-level court. This case caused a lot of controversy, and it drove the head of every pathology department in every teaching hospital in Canada absolutely nuts. They reacted very, very badly to this case, and that's because the case did something that really decades of legal tradition had not succeeded in doing. So this rule about ownership has never really been decided. As I said before, once it leaves your body, you don't own it. But no court has ever actually said that anyone else owns it. And there are US cases, like more cases I'm sure you're all familiar with, where the courts have not actually said there's anyone who owns it in particular. PLJAC is a case, and I'll talk more about PLJAC in the question period if you have any questions around the case. But the decision in the case is that diagnostic tissue is actually owned by the hospital. If they collect it from you, they own it. Now, I can tell you this right now, this case will not be followed in any other Canadian case. I think it was wrongly decided, I'm not going to digress into this case because it makes me mad, and there's a lot of things I can say about it. But that's just the story. The gist in the case is that it is now owned by the collecting institution. And the reasons are that it is personal property. It is no longer owned by the patient. The law is clear on that. And it is a medical record. And since hospitals own the medical record, then they do own it.
In the cancer genomics world, this is a serious issue.
Right.
Serious issue.
It is a big issue, but it's the courts creating a new classification now for diagnostic tissue, which is different from the conventional understanding of diagnostic tissue. It used to be that diagnostic tissue is held in a pathology department and is used for different regulated purposes. But this is a new category of diagnostic tissue that is now owned. Now, if a hospital owns it, they can do whatever they want with it. As an owner, you can sell, you can, to the highest bidder, you can do whatever you like. So you can imagine how this can dissipate a public resource. It's a huge problem for pathology departments. And now that I know this, next time I go into a procedure, I'm going to come with my lawyer. Like, I'm giving you property. It is in my body. I know it's a cancer, but leave it in there until we negotiate terms. And the minute we agree on those terms, then you can have it. Just in case it becomes good cancer that will generate money, I want to get mine now, right? So this case has huge implications. It's created a new classification for diagnostic tissue. So the question is this collaboration or is it a clash? It seems to somehow open up this new world where you don't actually have to go back to the patient ever again to ask the patient what they're thinking. You own the thing now as a hospital, so you don't need to obtain consent. You don't need to go back for secondary use. All of that stuff is gone. But you can imagine that if this became the case, no patient will give up their tissues easily. Everyone will want to negotiate terms with respect to tissue.
So in the supply chain that gets assembled around this, researchers are very excited that they can go on a website and order a bunch of human tissue
Right.
for pancreatic cancer for a class of studies, and they pay $100 a pop for well-characterized tissue
Right.
that has been got exactly through the system,
Right.
right? So that's one side of it. The other side of it is my tumor tissue holds the potential of helping treat my cancer
Right.
when treatments are show up 2 years, 3 years from now.
Right.
So I want partial rights. The third thing that I would like to anticipate is that just as hospitals currently consent you for your patient information, they could pay you for consenting. I mean, it should be exactly a ripe situation for at point of intervention, I sign off
Right.
and get reimbursed for.
Right, except that there are laws in Canada that says you can't do that. There are laws that say, and in most other jurisdictions, you can't sell your tissue, right? Because there's this whole, which is another thing I won't get into today, this whole thing around selling of tissue. So that'll be selling of tissue. So by law, you cannot get money for your tissue. I know I'm making jokes about it, but if you brought your lawyer in, your lawyer will not be able to negotiate terms with respect to actually alienating that tissue and receiving money for it. Okay, so I've published on this. I have the reference there, sorry. And it's in the, I passed around a bibliography if you're interested in reading more about this. So new kinds created from tissue, this is another rule that the courts have created, and this is from a case called Moore. New kinds created from tissue. So if a scientist takes that tissue and makes something from it, any little amount of human ingenuity applied to it changes its character. It becomes a new class. And that new class is owned by the person who made or created that thing. So if you derive cells from tissue, that cell now belongs to the person who derived it. So this is also a new class that applies to tissue. So what is then a new kind, and how much manipulation is needed to create a new kind is the question. How much manipulation do I have to apply to tissue so that the person from whom it's taken doesn't even have any rights over it? Now, I'm sure you've heard about the Moore case where this guy goes in for surgery, his spleen is removed, he goes home, and he's told to come back for tests. He doesn't realize that they're actually getting him for tests because they derived a cell that is commercially viable from his spleen, and they're trying to market that. And years later, he finds out that a cell that's commercially viable and that has made the University of California a ton of money was derived from his spleen, he gets really mad. He gets his lawyer involved. They sue the hospital and the regents of the University of California, saying, you know, you guys deceived me. You stole my tissue, essentially. You took the spleen from me. I thought it was going to be discarded. And you then derived something commercially viable from it, brought me in under the pretext that you were following up on me, but you were collecting information to help you sell my tissue, and that is stealing. His claim was that this is conversion, right? The court said, no, it is not conversion because it left your body. It no longer belongs to you. And more importantly, the cell was derived through human ingenuity. They applied human ingenuity to it, thus creating a new class which no longer belongs to you but belongs to the person who created that new thing and who applied human ingenuity to it. So just a little amount of manipulation takes it away from you. It will never be yours again. But the question is still relevant. You know, what do you have to do to the tissue to make it a new kind? Is it derivatives? Is it data? What level of manipulation do you need? Now, a definition of what the new kind should be, which comes from patent law, which is what I'm going to move into to finish up my talk, is where the new thing has markedly different characteristics from any that is found in nature, right? And I wonder if that's what creates a new class here. It's an open question still in the context of tissue-based research, what you have to do to make it a new kind. But there's some suggestion that a little amount of manipulation will take it out of the realm of ever being something that the person who owns the tissue, from whom mistaken, can have any rights to. Okay, I'm going to skip this, and I can come back to this because I want to talk about the third point, which is about patentable and unpatentable kinds. Now, generally, as you know, patents are granted on things that are new, useful, and obvious. This comes from the way patent is defined under the law. If it's new, if it's useful, and if it's not obvious, a patent will be granted on the thing. Now, this is the US definition. In other jurisdictions, there's different definitions that have been applied or different other ways of thinking about a patent that they've come up with that differ from this general definition. So, for example, in Canada, there's a distinction that's made between higher life forms and lower life forms. In general, higher life forms are not patentable and lower life forms are patentable. So even though that's not obvious from this definition, in Canada, you could not patent a higher life form, say like a transgenic mouse. In Europe, this definition is subject to a rule that says that what you're trying to patent cannot offend public order, which is a pretty broad class. You know, pretty much anything that they think will be offensive to public order is not patentable. So that's a problem in Europe. But in the US, this is the definition that is used. Now, in biomedical research, what is patentable fundamentally depends on whether it's a new kind. This is easy for researchers to prove. You know, it's useful. Yes, that's easy. It is non-obvious. That's also easy. Most patent law cases come down to whether it's new or not. So what we're trying to talk about here is fundamentally implicated in the way patent law works in relation to biomedical research. It has to be a new kind for it to be patentable. So the question is, what is a new kind for the purposes of patenting? Now, remember my clone? I had fun with that title. Michael Jackson, never mind. All right, so a clone, as I discussed previously, is generally considered a new kind for stem cell research purposes. We saw how the law is applied restrictively against clones. You know, you can't create a clone in many jurisdictions because it's a new kind that differs from the embryo. So you can't create a clone. Almost universally, everyone agrees on this. You can't create clones. Cloning is banned in almost every jurisdiction in the world, with the exception of a few like the UK, where cloning is allowed for research purposes, right? But in almost every jurisdiction, there's an agreement that you can't create this new kind for research purposes. Now, how about for patenting purposes? In this case, this US case out of, I think it's a California case as well, clones are not patentable because they are time-delayed versions of their donor mammals. That was what the conclusion the court reached, that the clone is actually not a new kind. So it is a new kind for the purposes of applying the ban to it in the context of stem cell research. It is not the same as an embryo. But this case says for patenting purposes, a clone is the same as the person from whom the cell that was used to make the clone is taken. It is not a new kind. A clone is simply a time-delayed version of the person from whom it was taken. So I thought that was really interesting, how in one area of law, a clone can be a new kind, and in another area of law, it is not a new kind. And this case also said that new means markedly different from something that is found in nature. It has to be something that does not exist in nature. And the argument in this case is that a clone is something that is natural. It is not synthetic, right? So it goes back to the thing we've been talking about since yesterday. A clone is synthetic. Even though in stem cell research, some might say it's an unnatural kind, but this case says it is not. And this is what I find really interesting. It is the law being applied in two different respects to reach two different conclusions. And it goes to how the law can sometimes collaborate or compete with science in these narratives. According to the judge in this case, there's nothing in the claims to patent the clone that suggests that clones are distinct in any relevant way from the donor animals of which they are copies. So in patent law, a clone is not a new kind, but in stem cell research, a clone is a new kind. So again, is it the collaboration or clash? That's the question here. And now my favorite case, and I'm going to close with this case, my favorite case in patent law is Diamond and Chakrabarty, which I think is the most important case in the past 100 years in any area of law, quite frankly. It's a really fundamental case, and I think it's the kind of case that really supports science in a very fundamental way, and it's a case about classification as well. So in this case, Chakrabarty, who's a scientist, created a synthetic bacterium which is capable of breaking down oil spills. So this was going to have huge implications for cleaning up oil spills, and it was an entirely synthetic product that's not found in nature. So he tried to patent it. He tried to patent this bacteria. So it was a human-made, genetically engineered bacterium. This is the ultimate new kind. It does not exist in nature. If you look at rustling, there's no reason why this should not be patented. So he took it to the US Patent Office, and everyone freaked out. There were two reasons why people freaked out. The first is, not a new kind. It is something that is similar to something found in nature, some kind of weird convoluted arguments around that. And the second is all the dystopic fears. This is going to lead to something that's not found in nature that will go crazy, it will be introduced into the environment, it will turn into something else that we don't know about, it will destroy things, it will lead to all kinds of hell. And that is what informs my title here, which I'll come to in a second. So the claim was rejected by the patent examiner because the invention is a product of nature and a living thing. That is just the reasoning that you get from someone who wants to say no, but knows that if they say no, you can go, well, that's crazy. You're the patent examiner, you just can't say no to me. You have to give me a reason. So the reason is essentially it's a product of nature. But even though it was very clear that this was human-made, it was engineered, but this raises the question we'll be talking about. Even if this is something that was designed by technology, is this still natural or is this synthetic? And the patent examiner initially said, no, it's not synthetic. Even though it was described as synthetic, he said, no, it's purely natural. So the case went all the way up to the Supreme Court of the United States. And the Supreme Court said, well, no. If you apply that definition in the Patent Act, new, useful, obvious, this fits the definition. It is new because it's not anything that we know about already. We haven't seen this before. It is clearly, using the literal meaning of new, new. It's also useful, obviously, and it's non-obvious. So the court said the patentee has produced a new bacterium with markedly different characteristics from any found in nature, and one that has the potential for significant utility. His discovery is not nature's handiwork, but his own. Accordingly, it is patentable subject matter. So again, the ultimate example of collaboration between law and science to move social order and facilitate social progress. But with respect to the second argument about how this is going to lead to all kinds of bad things down the road and you're going to introduce something that we don't know about. And this has relevance to synthetic biology. I know we didn't talk about that at this meeting, but there was some mention of that yesterday. Because said, look, the briefs filed by the patent examiner and by all those interveners, people who are concerned about this bacterium, lists a bunch of consequences that could flow from patenting this bacterium. But then the grant or denial of patents on microorganisms is not likely to put an end to genetic research or to its attendant risks. Let's put everything in perspective. It's not every time we raise all these horrors that we can think of them as justified. Some of these are just fears. It doesn't mean it's actually going to happen. Again, the ultimate example of collaboration. And this is the court saying, if we have a new category, we can actually defend that category against all kinds of dystopic fears, against all kinds of claims about consequences. And this is very relevant to a discussion of nanotechnology and nanomedicine. It's not that we can't have fears, but we can use those fears as a way to actually stop social progress. And then my favorite quote, which I'm going to close with, and this is what explains the title. Does anyone know the story of King Canute? So King Canute is it's an apocryphal anecdote. Nobody is actually sure that it actually happened, but it's about a king called King Canute who wanted to prove to his subjects that he's not infallible and that he's not greater than God and he can't do and undo things. So he took them to the ocean and said he was going to stop the tides. He was going to control the tides by commanding them not to come in. He was basically going to use his power as king to do that. And of course, he didn't succeed. When the water came over his feet and he became wet, he then turned to them and said, you see, even I as king cannot stop the tides from coming in. I'm incapable, even with all this great power that I think I have, of stopping certain things from happening. And so the judge referred to Canute commanding the tides, because it's an anecdote for how certain things can result in futility. And so the judge referred to that in describing this attempt to actually stop this patent by saying that legislative or judicial fiat as to patentability will not deter the scientific mind from probing into the unknown any more than Canute can command the tides. I think it's a very solid note on which to end, because it does show that law can, in fact, in certain areas, facilitate social progress by creating classifications or by justifying classifications or by creating kinds that allow scientists to do the work they do, even though, unfortunately, in other areas, it can also serve as an impediment to scientific progress. So finally, let's play the new or not new game show based on the ruling in Diamond. So I'm going to put something up and you're going to tell me if that's new, a new kind or not a new kind. So correlations between level of metabolites that influence drug effectiveness in treating autoimmune diseases. The winner gets a prize. New or not new?
New.
Not new.
Okay, by show of hands, new. Not new.
Correlation?
Yeah, there's a correlation.
Right, yeah.
Okay, not new wins out. Sorry, Alok. Cell-free fetal DNA used to detect fetal genetic defects. New? Not new. Yeah, Melinda wins out. Not new.
It's just
If you look at the bibliography that I gave you, there are cases where you can read more about this.
It's a different color.
How about DNA and cDNA sequences for BRCA1 and 2 genes?
Depends upon whether you work with Wisconsin.
New or not new? Not new, yeah. Everyone knows about this case. And then lastly, transgenic mice. The Harvard mouse? New? New in the US, not new in Canada. All right. All right, thank you. Thank you.
I'd like to push either you or Jasanoff, I'm not sure
Okay.
which of you, a little bit more on what you mean by collaboration.
Right.
Because it seemed like there was sort of an implicit political economic position behind what you're defining as collaboration between science and law, specifically a legal regime that promotes commercially exploitable research within the framework of a kind of more or less North American kind of antitrust and intellectual property regime. So it's like sort of just a free market notion of a free market political economy.
I completely agree. And the term collaboration is not meant to imply any kind of judgment either way, right? I think it's just the idea that if you think of these two cultural institutions as seeking progress or social order, right? They are working together to achieve whatever version of social order or progress you think is the ultimate result of this. They're not working across purposes. I think that's just what it means. They're not contradicting each other with respect to the question you're trying to answer. Now, there's a secondary question as to whether or not the thing that you describe as social progress or order is actually, in fact, social progress or order. And I think that can be challenged. I think that's perhaps what you're suggesting that.
Well, because social progress and order are moving targets and defined.
Right, they're defined differently. So it's possible to say that what you see as social progress is actually, in fact, not progress, right? But I think what Jasanoff is saying is they are working together to achieve something. Now, the framing of social progress is mine, because I do think, I'm very pro-science. I think, I don't see how one can define not looking as being progressive. And I don't see how one can define looking as not being progressive. I think the process of scientific inquiry in itself, right, is an attempt to bring about social order and progress. And maybe it's a political position, but I don't see how you can define it differently, except you disagree with science entirely, and then we're just, again, disagreeing with each other fundamentally. But I do agree that that's a political statement. That part of it is a political statement. But the collaboration piece is about law and science actually working together, not at cross purposes. Does that make sense?
Well, I mean, just to push back a little bit, what I worry about, I suppose, is there's a certain teleology to how collaboration's been defined, right?
Right.
You know, it's if something something not happening can also entail something else happening, right? So science and technology collaborate because in the case of Diamond v. Chakrabarty, because we know kind of what happened from there, and there's a certain research trajectory and patentability of genetically engineered organisms, kind of got a lot more people doing that sort of research. But you can imagine a world in which a ruling, to be counterfactual about it, a ruling in the other direction might have just set up another set of conditions in which scientists would have done other sorts of research, and you might have be able to, tell a story in which, just like, as I assume you would say, and Jasanoff would say, that the myriad genetics ruling was also collaboration.
No.
Well, but like the scientists would all raise their hands and say, we wanted the Supreme Court to rule against
it. Yeah, I suppose.
So in that sense, like sort of scientific consensus.
Right, I suppose, yeah. I mean, I think you're right about one thing, that we're framing the outcome as collaborative, and that's a judgment we're making about how we view the term collaboration. I agree with that. I'm not going to dispute that. I think you're right about that. But I also think fundamentally what judges do is to decide a dispute. And if the defendant in a case before a judge is a scientist who has a view of social progress or what might facilitate that, and they make that case. So as you have, Diamond is the best example of that. Chakrabarty makes a case that this is something that needs to happen so that I can open up the discovery, right? And maybe commercial exploitation is one of the ways of opening that up, right? And then the courts say, yes, we're going to facilitate that because we don't see any reason not to under the law. That's what I would define as collaboration, where judges, in the context of a dispute, right, take an approach that factually collaborates with the scientific point of view, whatever that might be in that particular dispute, and it's possible that doesn't fit with the broader social purposes, but I just think in the context of that dispute, it facilitates the scientific point of view in the way the dispute is decided, and it sort of shuts down all the noise around that scientific point of view. That's what I view as collaboration. And I make no judgments about whether the collaboration is a good thing or a bad thing. I just think it's a collaborative endeavor to move the scientific point of view forward.
I have some follow-up questions, but I'm
Right,
gonna
sure.
say-
I want to follow up with that
Right.
because I have a fundamental, I'm going to approach it slightly differently, which is that I have a problem with a lot of these rulings in the sense that judges are trying to provide remedies for bad laws, which
Right.
are passed by politicians that either have no real understanding of the science or progress, medical progress, for
Right.
example, or explicitly reject it by religious or other
Right.
other beliefs. And so, you know, you characterize it as collaboration, and to me, it's like, you know, these jerks are, excuse the French, these jerks are passing bad laws. You know, how can we live within it in a situation when we know they're bad laws? Now, maybe that's
Right.
just an
Okay.
extreme view, but
No, it isn't. I sympathize with the view, but I think it does speak to a scientific bias that I talk to scientists about all the time, which is the notion that just because the law doesn't support what I do makes it a bad law. Scientists are not the only persons in society. The scientific point of view is not the only point of view. Science is just one institution of the many that populate society, and legislators are well within their rights because they represent more than scientists to say, fine, we may or may not understand the science, but we see other things as being more important than the science in this case, and we've made the choice to go with religion or with that other thing, right? It doesn't make the law a bad law. That's the first thing. It doesn't make it a bad law. Because that reaction, I think, is just scientists saying, you've done something that we don't agree with, so that makes it a bad law. I don't think it necessarily makes it a bad law. That's the first point.
I think honest people can disagree with that point.
Right, because the thing is, you know, if you think about it this way, take the ban on creating human embryos in Canada, for example. Scientists argue that this impedes research, you know, and all the arguments that they make. And I'm sympathetic to that. I'm very pro-science. But at the end of the day, Canada is not a society that's made up of just scientists. Now, the other thing, too, is that scientists do have the opportunity to make their case and make it well, but they rarely ever do. So when the Canadian law was drafted, and I think I was talking to Alok about this yesterday, when Canadian law was drafted or was being prepared, the Catholic Church in Canada sent a delegation to Parliament to make their case. Scientists did not. They did not show up at all. So the science was characterized by Catholics, right? And they characterized it as people in basements creating nasty things, right? And legislators are like, okay, this is the only thing we have. We're going to run with that. So we did a study of the parliamentary debate. And the rhetoric you find in there will drive every scientist crazy, right? But that's because other points of view, which may be pseudoscientific or even non-scientific, dominated the debate. And legislators responded to that because they don't serve just scientists, they serve the entire country. Now, scientists had the opportunity to do that, and they got better. With every law that's been passed in Canada that would affect scientists now, they now put up a delegation of people to respond to that. I don't think it makes it a bad law necessarily to say. Now, to the second point about judges, that's the role of the judge, to interpret the law, not to make law, right? And I think I agree with you on that point, that judges may be responding to law that you consider to be bad law, but that's just their job.
So it's not really collaboration or clashing or anything
Right.
like that. It's, I mean, it's literally almost extra legal in the sense that each case is decided on its own merits as opposed to there's some overriding principle of what's best for society.
Right, I didn't mean to suggest that the collaboration is something that judges are thinking about actively when they do their work. That's just my framing of how I read the cases. I think I should have made that point earlier. That's my framing that I bring to the topic, to the way I see how this works out. And it's a framing that's loaded with bias. I acknowledge that. It's loaded with my bias about what I see as progress and about how I think law should facilitate that progress. But it's not intended to be a framing of how judges think or act or apply the law in these cases.
So I wanted to bring up something in relation to Evan's point. Law has this characteristic that it brings a standing army to whoever makes the case, right? So the law defines rules, and if you're on the wrong side of that rule, the standing army comes and prohibits you or controls you. Whereas if you're on the right side of the rules, you can practice whatever you intend to practice freely. But there's a standing army, right? That's what, it's resourced, it's paid for, and it's there on the letter of the law. So if you take the two examples of when recombinant DNA situation was growing, which was now re-invoked during the CRISPR situation, that the scientists do not want the system of rulemaking that brings the standing army and defines permissive and prohibitive regimes. They want to self-regulate. So they're producing their norms, they're self-regulating, and they really don't want the standing army involved. As soon as the standing army gets involved, if laws get written in the Federal Register, it's in the control of people we have disagreements with, but problems, you can have your disagreements, but now there's a standing army that's gonna come and block you from doing things. And so I think when you see it from that side, that the scientists who did not show up in the Canadian legislation process, they let the standing army operate. I mean, the larger intersection of social worlds that we call the world, the resources of the state are brought to bear according to a set of rules.
Right.
And I think that's how you're representing collaboration,
Right.
not on the intentional aspect, but the permissive versus prohibitive regime,
Yes.
because you cannot escape, once the laws are produced, the standing army will be brought to bear,
Right.
whatever the nature, character, flaws of the law, and you can keep having your paper argument with the judge.
I should get to explain all my concepts back to me. That was brilliant. I completely agree. I do think, the one point to note is examples like in the stem cell research context are rare. You're not going to find too many examples of the law actually directly regulating anything, or politicians getting together to enact a statute to stop science from happening. In the US, it's a very fraught issue. You can't actually do it in the US, at least at a federal level. In Canada, this is the only example I can point to. And it wasn't even an attempt to regulate research directly. It was an attempt to regulate assisted human reproduction, which then touched on related research. So it was indirect in a sense, but still direct in the sense that this is the first time you're having rules that affect science directly. Even in the CRISPR situation, I doubt you're ever going to see statutes that say you can or cannot do this. The problem, though, is when technologies or emerging technologies interfere with rights of individual citizens and then create situations where they go to courts to adjudicate disputes that implicate those technologies and implicate individual rights. And courts have to make a ruling. Now, the way I see collaboration is when judges say, fine, there's a way to interpret the law to allow for science to operate. And I see that fundamentally as a matter of progress. That's my bias. I think anytime science is allowed to operate, free of all the things that we talk about, ethical worries or moral worries or any of the other things that we talk about, that's a good thing for society. So there's an implicit bias on my part in that, and I acknowledge that. Anytime judges do that, they find a way to interpret the law, such as what happened in the UK example, where the judges said, look, we know the definition doesn't say embryos other than by fertilization, but that's what we think the legislators meant. I see that as judges fundamentally collaborating with science. I think everyone would disagree. Yeah.
I just want to differentiate science as a monolithic entity, which it may well be in legal discussions. I mean, there's a well-defined form of science that scientific expertise takes on when it enters into legal regimes. But then in the wider world of culture and of the practice of science, it's hard to point to.
I will not disagree with that point. I had my criticism of science, as was clear yesterday when I was pushing hard on the reproducibility problem. But I think in this case, science is presented in that sub-monolithic version. These were scientists who were applying for a license to do scientific work. It wasn't an issue in the case as to what informs the kind of work they're doing, who pays for it, whether it's actually legitimate science. That wasn't the question. The question is, can we give them a license to actually do something that we acknowledge, taking a broad view of the matter, is scientific research. Now, if you start to break it down, I agree that there can be other forces applied to it that may not be collaborative in the sense that I define it, that may, in fact, and I have also, and I've written a lot of stuff about how you can actually, the culture of science itself can be regulated by law. Things around commercialization of research and its effects, things around reproducibility, research ethics. I agree with that fundamentally. But I think whenever you have disputes where science is being presented as an institution, and judges are called upon to decide whether or not to facilitate what that institution is looking for. I think where judges do things, use interpretation as a way to get around this, the stumbling blocks or the things that impede that thing from happening, I think that's collaborative in nature. Collaborative with the institution, not necessarily with the elements of that institution.
Yeah, I mean, the collaborative framings is really interesting. But the question I have is, it doesn't seem that applicable to patent law, because I mean, the nature of patent law is that the claimant is trying to make this very ambiguous, if it's done effectively,
right,
very ambiguous class that applies to everything, one-click computing or something, right?
Right.
And the patent officers kind of restrict that in the public good, but often they don't very well, and so that restricts other people from doing research.
Right.
Economically, right? And so it seems like a strange framework.
So that's what the losers will tell you. I'm not calling you a loser, by the way. But the winners, scientists created the patent system, to my mind, right? They like it because they understand it. They have no alternative to it, right?
Individual scientists like it sometimes.
Right.
As a collective, I'm not so sure.
Yeah, I mean, we can debate around that, but I think they haven't actually come up with something that will replace that system. And when it benefits them, they quite like it. They quite like the fact that there's something that allows them exclusivity, right? In exchange for, to be able to commercially exploit the thing while having this bargain with society that we're going to actually share the research. If they come up with something that can replace the patent system, I'll be willing to move to the other side. Because I actually don't like the patent system, but I think as far as someone like Chakrabarty is concerned, getting a patent is essential to what he wants to do, right? And he sees that as part of what he wants to do. He wants that to happen. And he wouldn't want a classification that shuts him down on that. And in fact, US patent law is seen by scientists. That is why the US patent system is where you first patent your thing. It's not ethicists or lawyers that do that. Scientists come to the US first. It is the most expansive system. You get a US patent, chances are, everywhere in the world, you're going to be able to get a patent. I see you're disagreeing.
I don't think the patent system is science-oriented. I think it's technology, engineering-oriented. I think there's a big difference. It's not to say, I'm not saying that scientists can't switch over to a technological and commercial mode.
Right.
But that's not the driving force. Patents are not the driving force.
I actually think since the Bayh-Dole Act, and I'm saying from the 70s, I think scientists are fully in a technological mode. If you're a scientist who's not in that mode, I don't know if you can call yourself a scientist anymore. I know it's a big claim. I don't have time to defend it.
Yeah.
But I can tell you now that based on studies that I've done, any scientist who's working in a non-commercial mode, you're still a scientist. Of course, the nomenclature applies to you, but I don't know what kind of scientist you are. Quite frankly, I think
it establishes an incentive system,
right?
That
for good or bad.
It essentially pulls a certain class of science projects forward.
Right.
People write more grants in alignment with it.
Right. I mean, the NIH is begging people to apply for basic research grants. This was in the news 2 days ago. NIH is begging. We have money for that. After years of telling people, we don't have money for that. They're now saying, no one is applying for those grants. Come get basic research money. Because everyone is now applying for applied grants. I mean, that's a topic for another day.
They're doing science not for scientific reasons at that point. They're doing it for technological or economic reasons.
But I've defined science as
I think that's a big difference.
I define science as an institution. I think it's an institution that operates with all kinds of pressures, manifestations. I don't think science is just what scientists do. It is an institution, pretty much like the church is an institution that has all kinds of things that come with it, including the commercialization of things. I mean, that's how I see science. I'm defining it as an institution.
I want to bring up a story of a completely different standing army
Right.
that regulates things.
I like that term, standing
And
army.
something with nanotechnology. So there's this company that came out of Silicon Valley that wanted to go personalized medicine, nano container for blood, 140 analytes. We'll set up the shops in Walgreens, and you can run your test and self-diagnose and go and get something. So, cut the doctors out, use the web, and once you've got your test, you can decide which doctor you want to prescribe a particular medication, right? And they got funded enormously, and they've just gone through this precipitous fall at the hands of the FDA
Right.
that is responsible for regulating, certifying, credentialing agencies that expect to provide a technology-based service that it has medical consequences. So they were, restricted to New Mexico, put on probation, and then shut down.
Right.
And that's a different, and you could say that, the FDA's track record is to keep changing the rule book for regulating new technologies out there. So they've been flooded for 15 years with multi-analyte signature-based testing, like microarray-based testing, and it's very hard to establish those signatures as having the diagnostic efficacy based on previous criteria, scientific criteria, which is mechanism-based. When you have signature-based, you cannot produce a mechanism-based story, and that used to be their ways. And so they've been trying to adapt. There's a special division that's been trying to adapt. So they are, in a sense, to use the permissive versus inhibitory kind of interpretation of collaboration. They've been trying to expand their ability to be permissive towards new scientific regimes that are in the marketplace. And
They actually, that's perhaps another area where classification is also relevant. There's case law on that as well. There's case law in the stem cell context. There's a company out of Texas that will purify stem cells and then introduce them back into the patient. Adult stem cells, they were working on adult stem cells. And they were doing this, and they classified it. This is actually really interesting. That's a fourth example. So maybe there should have been 4 ways when I think about it. But the company claimed that was medical treatment, not the kind of therapy that FDA should regulate. So they say a patient comes in, we take their cells, we purify it, we put it back in them. How is that subject to FDA regulation? We did not make a product. It's not a new kind. We're simply treating a patient. But this is an attempt to sort of take advantage of the stem cell hype. There's now over 107 clinics in the US that offer, I should say 100. 107 seems pretty random, but I'm just quoting the article. There's an article in the Washington Post that says about 107 US clinics offer this service. And so the FDA was faced with a problem where you've taken a concept that has not been shown to work in any way and that can in fact be dangerous, and you're using it to treat patients. And you're saying it's not therapy, it's not a drug, it's not a medicinal product, it is a medical procedure, and there's nothing wrong with providing a medical procedure. So they shut down these clinics, and in this one case, the company sued the FDA. And the court said, no, we're not going to allow this claim to succeed. The FDA has a right to regulate you. What you define as a medical procedure is not a medical procedure. It is, in fact, a drug. And it should be FDA regulated, right? We've seen the example of Theranos as well. What's going on with Theranos? FDA is fully involved in sort of this classification exercise where they're going. It's something that we can regulate. It's been classified under the law. It is not a new thing. And I think it's a constant struggle for the FDA to decide, are we going to permit or we're going to prohibit. But that's pretty much a fourth story as well in relation to this topic about how law can do that.
The danger when scientists stop doing science.
Yeah, it's
On
that,
provocative
that I agree with.
Thank you.
All right. Thank you.